Excellent. We have a quorum. And so we will begin with public hearings. First bill up will be Senate Bill 937. Senator, please proceed when you are ready.
Thank you, Mr. Chair, members of the committee. Senate Bill 937, like the chairman said. Mike Bernskoetter, representing District Number 6.
Senator, I'm not sure if the mic is on.
The light's on.
Oh, is it? Okay.
Can't hear me? Now can you hear me? Okay. Thank you. So this is a land conveyance bill. As all you know, we have a land conveyance bill every year. It's brought to me by the Office of Administration. Office of Administration has talked to all the senators that have a piece of property that's affected by these land conveyances. I have a list of them. If the chairman's okay with my chief of staff passing them out, looks like he is.
Yes,
Okay.
that's quite good. Thank you.
Thank you. There's, I think there's 11 parcels of land, and I imagine there'll be more before session's over. Usually there's more as session goes on, but you have a handout of all the pieces that are being proposed to be conveyed right now. I'd be happy to answer any questions.
Thank you for that presentation. Does the committee have any questions for the bill sponsor? Seeing none. Any witnesses here testify in support? Senate Bill 937. Please make sure you filled out a witness card and proceed when ready.
Hannah Swan with the Office of Administration. I'm here to testify in support of this bill. I'd like to thank Senator Bernskoetter for bringing it forward. The state has a number of properties, some that have been vacant for a while, others that are at max capacity where we would like to be able to sell the facility potentially and expand for more space, specifically in Springfield. All of our properties there are at max capacity right now. I can go through this list, or just if there are any questions about any of these properties, please let me know.
Yes, I believe the list has now been fully distributed to the committee. Are there any questions for this witness? Seeing none, thank you for that testimony.
Thank you.
Further witnesses in support? Seeing none. Are any witnesses here in opposition to Senate Bill 937? Seeing none. Are any witnesses here to testify for informational purposes only? Seeing none, that will conclude the public hearing on Senate Bill 937. We will next proceed to public hearing for Senate Bill 856. Senator, if you are ready, please proceed when you would like to.
Good morning, Mr. Chairman, members of the committee. For the record, Senator Rick Brattin, 31st Senate District, bringing forth Senate Bill 856. There has been a substitute that has been distributed as well. What the underlying bill seeks to do is to adjust where Cole County lies within the District Court of Appeals and moving it from the western into the eastern. The eastern is a more robust, there's more judges, there's more solicitor generals, and the capability for better caseload and ease of capability to be able to work through cases. I think it just makes more sense. That's what this would do. The substitute has to do with sunshine requests and legislative workings and our duties and responsibilities. This is what we're doing is legal work, and I think it needs to be treated as such. We're dealing with a bunch of sunshine requests and the manipulation of the sunshine laws. I think that were intended to ensure people had the capability to have access to the things that we're doing, but to impede the capability for us to do our work was not the intent and should not be the intent. In the same case, if you had an attorney trying to help you on your case, but they had the right, or people had the right to interject themselves in your attorney-client privilege, you'd say that'd be an abuse of that. Well, that's exactly what's occurring with the current system. This would rectify the kind of the loophole that we've seen. So for that, that's what the substitute would do in dealing with that aspect. So be happy to answer any questions.
And the changes that you're alluding to here, those are on page 9 of the substitute, is that correct? Looks like section 610.021.
Yes, that'd be correct.
Looks like in section 1 there. Okay. And you indicated that is to create a work product exception for the General Assembly?
Yes, yeah.
Okay.
Yeah, because right now, I don't know if there's subpoenas going out, there's sunshine requests, and then subpoenas for our research team. Well, they're in the middle of legislative work right now for us. We have a very limited window in which to actually do our job. Well, now we have 30,000 documents being requested on top of the work we're doing. I think it's an absolute abuse of the system that the people, well, they have transparency. They have the capability to come right here, testify, see everything being transparent. But what's being done is an abuse, and I think this really does make sure that that's solidified.
Thank you for that presentation. Questions for the bill sponsor from the committee? Yes, Senator, please proceed.
So, Senator, I guess I'm unfamiliar with what you're talking about with the 30,000 documents. So can you fill me in on that?
Yeah, so there was, with our special session, there was first a sunshine request that came down for a bunch of documentation for the whole process of a session, basically, and wanting all the documentation with that. They submitted it to our legal research, and then Huh?
Ours meaning like the Senate's?
Yeah, the Senate's. I believe that's so.
Okay.
The Senate research team, and then they hit it with a subpoena for those same documents. So now they have to get these documents, 30,000, and have to review all this stuff while also having to draft all our bills, do all our substitutes, do all these things, and it takes precedent and it's a timely manner. So it's a total impeding of our capability, their capability to be able to serve us and be able to do this job. So this is just putting parameters in place that, yes, we should be able to communicate as legislators of like our intents and have these sorts of discussions. That's our legal proceedings. Just like you would with an attorney, you have that capability to have those discussions and not be admissible before the court of public opinion. I know we can sit and say that, but there has to be some level of capability to have a free, fair discussion without, literally being destroyed because.
Well, I understand what you're talking about in theory, but, if there's ill intent, if things aren't on the up and up, the taxpayers and the Missourians deserve to know.
Well, but every
is this about
vote
the
we
stadium
take, every
scheme?
bill that we have is, in essence, the end product, every bit of it is before the public.
Is this
They're able
about
to
the
see it.
stadium or the gerrymandered maps coming down from D.C.?
Well, this has to do with just the process of the legislature. I mean, regardless of the subject.
I'm trying to figure out what the 30,000 documents would be. Is that
well,
the
it
maps?
has to do, I think, with. Well, I'm not sure. I just know that subpoenas come forward. I'm not in the case, but I just know that's been brought forth before our Senate. I don't know which one it's
Okay.
for.
Yeah, and I'm not grilling you as much as I had not heard of this at all until
Yeah.
just now. So,
Yeah.
Another question I have is connected to this. So, probably about 10 years ago, when we had the Rams fiasco and this, the scheme to just sort of, ditch St. Louis, and then the NFL and the Sports Commission and Sports Authority and everything. Eventually, there was a court case, and several of us were. They attempted to drag several of us elected officials into that. And at the time, the Missouri Ethics Commission said that elected officials couldn't use money from their campaign committee to defend themselves, even though they were conducting and voting in their official capacity as a lawmaker. So would that be something you would be interested in looking at as well? I feel like, a powerful entity like the NFL and their lawyers we're using the legal system to harass elected officials for opposing, for filing a lawsuit, things like that. So I think that it's really could have a chilling effect on all of us as electeds if we're going up against big multi-billion-dollar organizations and we can't use our campaign committee to pay for our legal fees. I had to pay for things out of my own pocket.
Oh, wow. I wasn't privy to that. I didn't know that.
Okay.
But I'd be happy to discuss with you and see how we can,
Okay.
make sure
great.
those, yeah.
Thank you.
Further questions? Yes, Senator, please proceed.
Senator, do you mind looping me in on those conversations? I tend to agree with you, and I have a little bit of concern about the cap of donation amounts, being able to, an hourly billable rate can be $950 an hour, 225, or, whatever the max donation is. That gets eaten up pretty quickly. So let's talk and see if we can't figure that out.
Further questions for the bill sponsor? Seeing none, thank you for that presentation. Witnesses here to testify in support, Senate Bill 856. Please make sure you fill out a witness card and proceed when ready.
Thank you, Mr. Chairman. Is this on? Thank you, Mr.
Just make sure that
Very good.
it's
It's
close
on.
to
It's
you.
on.
I
Very
think
good.
it is on, but it is not super sensitive.
Very good. Thank you, Mr. Chairman, members of the committee. And I did submit a witness form online, so your committee should have that. Mr. Chairman, I'm testifying in favor of Senate Bill 856. My name is Samuel Lee, registered lobbyist with Campaign Life Missouri. I want to go on record in support of this excellent legislation. And I'm just testifying on the bill as it was introduced and not the additional parts that have been offered in the committee substitute. It's very appropriate, Mr. Chairman, that you hear this bill today, the day after Governor Kehoe issued his Executive Order 2603, which formalizes the Missouri Government Responsibility, Efficiency, Accountability, and Transformation Initiative. That is the Missouri GREAT program to promote efficiency and accountability in state government. Because what this bill does is it promotes efficiency and accountability in the other branches of government, including the judiciary. And the bill, by specifically placing Cole County, the seat of government, in the jurisdiction of the Eastern District of the Court of Appeals, which is something only the legislature can do. The courts can't do that on their own. That creates an inherently more efficient use of state resources and taxpayer dollars for at least 5 reasons. First of all, the Eastern District Court of Appeals courthouse is closer to Cole County than the Western District. It takes, according to Google at least, 2 hours and 10 minutes to get there, whereas if you go to Kansas City, it's anywhere from 2 hours and 27 minutes to 2 hours and 33 minutes. And of course, depending on the traffic, it could be a lot longer, as anyone who's traveled back and forth to Kansas City knows. Secondly, the Missouri Attorney General and Solicitor General's offices are in the old post office in St. Louis. They are literally in the same building as the Eastern District Court of Appeals. The Attorney General's office is on the 2nd floor, and Solicitor General's office and the Court of Appeals is on the 3rd floor. So that saves a lot of time and inefficiency in terms of driving, traveling, sending documents, mailing documents, having delivery people get those, and that certainly is a savings to taxpayers. Third, the Attorney General's office and Solicitor General's office in St. Louis are just a few blocks away from the Thomas F. Eagleton United States Courthouse. So the taxpayers' legal representatives can literally have their attorneys, that is the Attorney General and Solicitor General, walk 10 minutes. So they can be in the Federal District Court and they can be in the 8th Circuit Court of Appeals for argument, for filing of briefs, for whatever it is they may have to do. That certainly is an efficiency. And in addition, there are lots of cases that are in the 22nd Judicial Circuit, which is the city of St. Louis, and that's just a few blocks away as well. So instead of having to have attorneys and others from traveling all over the state, they can do a lot of the business of the state in defending the laws and defending the rights of Missouri citizens right within a few blocks of each other. Fourth, and the sponsor mentioned this, the Eastern District has 14 judges, which is the largest court of appeals, whereas the Western District has 11 and the Southern District 7. So you have a larger number of judges who can hear cases more quickly. You can have a greater variety of 3-judge panels. You're not having the same panels hearing the same cases over and over again. That's a certain level of efficiency. And lastly, I want to focus in on something which you may or may not recall, but this bill is very important to protect the security of our judges in Missouri, as well as the Attorney General and the Attorney General's representatives, Solicitor General, Assistant Solicitor Generals, etc. You may recall last July, the Highway Patrol arrested a man named Dustin Bibens, 26 years old, from Stone County, after he allegedly threatened Missouri Supreme Court justices on social media. He was angry that the Missouri Supreme Court had overturned, at least temporarily overturned, a lower court Jackson County decision, and that Missouri's pro-life laws were back into effect. And he posted something on Facebook where he threatened to, the people have voted, and we have plenty of bullets to enforce those majority votes. Threatened to shoot, and named the 7 judges on the Missouri Supreme Court, as well as their address. He's arrested, he's in jail, he's facing 49 years in prison. The point is, when you have the ability in a smaller geographic area to provide security, in this case we're talking about lawyers for the state, judges, people traveling back and forth, you have their city, state, and federal law enforcement to greater capacity. That's going to keep our judges safe and keep our lawyers safe here in Missouri. Happy to answer any questions, Mr. Chairman.
Questions for this witness from the committee? Seeing none, thank you for that testimony. Further witnesses here testify in support. Please proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Susan Klein, representing Missouri Right to Life, here to go on record in support of Senate Bill 856. We thank the Senator Brattin for bringing it forward. I haven't seen the amendment or the substitute yet, so I'm testifying on the main bill. And Missouri, back in 1945, we put in the counties in who would be in the Eastern District Court of Appeals, and a lot has changed since then. We've come a long ways. I think it's time, when we look at government efficiency, we need to look at every aspect of that. Absolutely for the judicial, because we know our courts are overloaded with cases. So what you've heard, obviously, I agree with. I would say, just from a personal perspective, we used to live in Tipton, Missouri. Tipton was always considered to be the most western county that was in our particular area code and our particular status in the state. So when you look at that, Cole County is in the Eastern District. It's considered to be an Eastern county in the state of Missouri. So I think it would just be, common sense, government efficiency to look at, as we look at our court system, more judges in the Eastern District. It would just make more sense and make better efficiency of government to put Cole County in the Eastern District Court of Appeals.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses testify in support. Seeing none, any witnesses here testify in opposition? Seeing none, are there any witnesses here testify for informational purposes only? Seeing none, that will conclude the public hearing on Senate Bill 856. We will next proceed to public hearing for Senate Bill 918. I believe I saw the sponsor in here. Oh, yes, he's right there. He was right in front of me. I was looking in the wrong place. Senator, please proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Jamie Berger, representing the 27th District, which is Scott, Cape, Perry, Ballinger, Madison, Iron, and Reynolds County. Thank you for allowing me to present Senate Bill 918. In August 2017, Missouri amended Missouri Statute number 490.065.2 to match Federal Rule 702 on the admissibility of expert testimony in civil and criminal litigation. In doing so, Missouri joined the majority of states that already adopted Federal Rule 702. The amendment of 490.065.2 proposed in Senate Bill 918 is a continuation of the decision we made in 2017. This language exactly matches the changes made by the Supreme Court to Rule 702. It is a clarification of the gatekeeping function of the courts, and we anticipate it will provide clear guidance to our courts. The clarification of the proper application of the expert admissibility rules will make things easier, not harder, for trial judges, providing them with a clear checklist of factors against which to access preferred expert testimony. Requiring reliable and relevant expert testimony is neither pro-plaintiff nor pro-defense. It is a fundamental protection that is inherent in all evidentiary rules, such as hearsay, the best evidence rule, etc., and necessary for jurors to be positioned to provide just verdicts. A number of states are already taking the same action to update their state laws to match a new version of Rule 702, including Kentucky, Louisiana, Ohio, and Arizona. Similar proposals have also been made in Alabama and Mississippi and other states. After this expert presentation and expert language, I am not the expert witness on this bill, by no means. The people following me will be the experts to answer most of the questions, but that's my presentation, and thank you.
Thank you for that presentation. Any questions for the bill sponsor from the committee? Seeing none, thank you again. First witness in support, Senate Bill 918.
Good morning. My name is Dana Fries. I'm the President and CEO of Healthcare Services Group in Jefferson City. We insure approximately 60 not-for-profit hospitals throughout Missouri and more than 2,000 physicians. We provide both professional liability and general liability insurance for Missouri healthcare providers. I'm testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. Why do we have special evidentiary rules for expert witnesses? It is because their testimony involves specialized opinions based on technical and scientific knowledge, which can mislead a jury if it's not vetted by the judge as being sufficiently reliable to be considered by the jury in the first place. These special rules act as a judicial gatekeeping function to ensure the expert is qualified, the methods used are reliable, and their testimony actually helps the jury understand complex facts. Experts don't just comment on what they observe. They interpret data and draw conclusions that juries are likely to defer to, even when those conclusions are wrong. Once unreliable expert evidence reaches a jury, the damage is often irreversible. As a gatekeeper, judges should exclude experts whose methods are flawed, irrelevant to the case, or whose testimony is more prejudicial than helpful to the jury. The jury should be educated by the expert, not misled. The judge's role is not to decide if the expert's conclusion is right, but rather the methodology used by the expert is reliable enough to be heard by the jury. Judicial gatekeeping should happen with more regularity in Missouri state courts, and Senate Bill 918 will assist in that process. The Missouri Court of Appeals decision in Hewitt versus Kent Branson, MD, is a good example of what happens when prejudicial expert witness testimony is not vetted in advance and is provided to the jury. In this case, a birth injury case, a biomechanical engineer who was not a medical doctor and who had never delivered a baby was permitted to give an opinion that maternal forces of delivery were the specific primary cause of the child's brachial plexus injury. This led to a defense verdict, and the plaintiff appealed. The admission of this evidence by the defense in that case was deemed improper on appeal by the Court of Appeals, which resulted in a new trial, a waste of time and money for all to have that trial. The purpose of Senate Bill 918 is to prevent misapplication of the expert evidence rule by clarifying that the trial court must decide on admissibility of expert opinion employing standards comparable to the updated Rule 702 of the Federal Rules of Evidence to be consistent between Missouri and state courts. The party offering the testimony, either plaintiff or defense, must establish its admissibility to the court by a preponderance of the evidence. That's a new language in the bill. And the trial court's gatekeeping function is ongoing. The decision to admit testimony does not allow the expert to offer an opinion that is not grounded in the proper standard developed under the federal rules. Amended Rule 702, which is incorporated in Senate Bill 918, sets forth the best process and standard for admission of expert witness testimony. Admission of unreliable expert opinion testimony can mislead juries, undermine Missouri civil justice, and erode our trust and confidence in Missouri state courts. We need a consistent and reliable process to determine what evidence is admissible and should be considered by a jury. For the burden of proof in our judicial system to be effective and to ensure consistent results across the state, the Missouri evidence rule should be updated as provided in Senate Bill 918. This is accomplished by 1, the trial judge deciding whether the testimony offered meets the rules prior to allowing a jury to hear the testimony. The party offering the testimony, whether a plaintiff or defendant, bears the burden of establishing a sufficient basis and reliability of the expert's methodology and application to the facts of the case. The trial court's gatekeeping function can be improved. It is not acceptable to merely state that not all Missouri state court judges have law clerks. Of course, not all experts' opinions are going to be challenged by the other party, so there will not be a need for a hearing for every expert. My organization spends millions of dollars a year in defending lawsuits. I'm not going to spend money challenging an expert witness testimony that ought not to be challenged. That would be a waste of my members' money. But there needs to be a meaningful option to challenge expert testimony and to avoid the result in the Hewitt case where the case had to be remanded for a new trial. So if that gatekeeping function is not enforced through an amendment to the Missouri evidence rule, then the result will be, in most cases, that all expert testimony is presented to the jury, and the jury is forced to sort it all out, despite the fact that the jury does not have legal training to apply the standards adopted by Missouri law. Although it is the province of the jury to consider the weight and credibility of properly admitted evidence, the jury should not be forced to consider disputed expert testimony that has not been reviewed by the judge to determine if it is sufficiently reliable to be considered. So I urge for your adoption of Senate Bill 918. Thank you.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again for being here.
Thank you.
Further witnesses testify in support.
Mr. Chairman, members of the committee, thank you for having us all here to talk about Senate Bill 918 today. My name is Mark Dunn. I'm an attorney in Cape Girardeau, Missouri. I practice throughout southeast Missouri, but also throughout the state. I'm here on behalf of myself as a working attorney in support of Senate Bill 918. Thank you, Senator Berger, for bringing this forward. As you know, the Senate Bill 918 seeks to amend our current statute, which already contains requirements for a gatekeeping function by the judges in our state, but simply seeks to clarify the requirements that are on the proponent of the evidence and also on the judge who's reviewing it and making the decision about the admissibility of the testimony. As Senator Berger pointed out, a number of states have already adopted it. There are a lot of states who are considering it. 10 current efforts around the country, Tennessee, Mississippi, Alabama, Georgia, Texas, Missouri, Illinois, Indiana. All our neighbor states are doing the same thing. The point is to update our rule so it matches the federal rule, and there's a reason for it. But before we get into it, if you read the case, not case summary, see, I'm a lawyer, so I'm always reading case summaries, right? If you read the bill summary, you might think, or might come away with the impression that there's some sort of major substantive change that's going on here. Look at the bill itself and you realize we're talking about changing 2 sentences, just 2 sentences. They're important 2 sentences, but it's not changing substantively what the judges are required to do, nor what the attorneys were required to do. It simply clarifies that. Why was it necessary to clarify it? Well, in federal court, they found that courts were often taking the factors for reliability that they were supposed to be considering and simply saying, well, that goes to the jury. That's a matter of weight, not admissibility. Well, that is incorrect, completely incorrect. The whole reason for the original amendment of Rule 702 in 2000 was to install this gatekeeping function for judges. They shouldn't just turn over the reliability factors to the jury. Now, last time we were here, some comments were sort of along the lines of, if it's not broken, don't fix it. Well, it is broken. It's broken in Missouri as well. A lot of courts in Missouri and a lot of lawyers, including cases I've worked on, have thought and taken the position that the factors of reliability should simply go to the jury. A couple of other things it's doing, though. First, the bill clarifies who's got the burden, right? It's the proponent of the evidence. For some reason, some courts and lawyers thought because these issues usually come up in the context of a motion to exclude testimony or a motion in limine to try to exclude an expert's testimony, that somehow the person filing the motion carried the burden of deciding, of convincing the court one way or the other. That's not right. It's on the proponent of the expert testimony, and this is consistent with other kinds of evidence, right? Hearsay evidence. If I want to introduce a document into evidence, that's going to draw an objection of hearsay, which it should. I'm now required to show that an exception to the hearsay rule applies, right? As Mr. Freeze pointed out, another change is just pointing out that the standard for finding that the factors are present for reliability is now more likely than not. That's not a major change either. That's simply the same kind of standard that we follow all the time in cases. But the reason that clarification was necessary was that lawyers and judges were taking a lower standard and basically saying that there was a presumption of admissibility. Well, that's not true. We don't have a presumption of admissibility. In Missouri, under our current statute, and it needs to be clarified that that's not the case. In addition, the last change in these 2 sentences relates to the court looking at the expert's opinion to see that it reflects a reliable application of the principles and methods. So too many courts and lawyers were stopping at methodology and saying, well, it looks like a good, solid methodology, so we're fine, right? Well, no, it depends on what's the opinion that comes out of that methodology. Is it consistent with that methodology, and does it reliably apply these principles to the facts of the case, right? The judge is tasked with deciding the admissibility of expert testimony. As our rule stands right now, we're just simply trying to clarify it for both lawyers and attorneys. Last time we were here, one of the complaints was that this is going to create more work for the judges. This is not going to create any more work for the judges than they already have. They're already obligated under our current statute to perform this gatekeeping function. I know it's a lot more difficult now because they have to consider reliability factors as opposed to just simply saying, is this expert witness qualified to offer expert testimony or not, right? It's a more complex decision. But the work involved in making that decision ought to be the lawyer, all right? If I want my expert to testify, it is up to me, as the lawyer, to show the judge that all the factors of reliability are present with respect to my expert witness, right? And then the judge does what judges do. They make a decision, all right? Now, do they sometimes have to write opinions? Absolutely. Common practice in Missouri is for a judge to ask a party who has submitted a motion or a response to offer a proposed order. We do it all the time. So and some of the local rules in our courts specifically require that you file a proposed order when you do one of these hearings, right? And so the lawyers have an opportunity to help the judges. It ends up really being more work on the judges, more work on the lawyers than judges for this gatekeeping function to work. But nevertheless, we're talking about 2 sentences again, right? That's not increasing a lot of work for me as an attorney or for any judges, right? It simply clarifies what we're supposed to be doing now. We also heard that this was going to hurt plaintiffs' lawyers. As Mr. Berger pointed out, this is neither a plaintiff nor a defendant bill, really. The rules relating to expert witnesses apply to all of us evenly. And in fact, it's not even just a tort case, right? You've got contract disputes, we've got experts in divorce cases, we've got experts in all sorts of litigation. These rules apply to all those cases, right? So it's not just personal injury that we're talking about here. These minor changes to clarify the rule won't make anything more difficult for plaintiffs' lawyers than it is now. If they're having trouble retaining experts, there are various reasons for that. I know because I do about 30% of my work is plaintiff's work. Sometimes it is hard to find an expert witness. Depends on the kind of case, depends on where you're looking for experts, but at any rate, it's not a pro-defendant rule, and I think it'll be better for all of our clients. Bottom line, this doesn't make anything more difficult for anybody. We just need to do our jobs as lawyers. We have to do our jobs as judges, and this clarifies how we go about it. And in fact, it makes it easier because now we can understand what it is we were supposed to be doing in the first place. Thank you very much.
Yes, thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again.
Thank you.
Further witnesses in support?
Morning, Mr. Chairman, members of the committee. My name is Phil Goldberg. I am a partner at the law firm of Shook, Carney & Bacon. It's based in Kansas City, though I work out of our D.C. office. And today I'm testifying on behalf of the United States Chamber of Commerce. The sanctity of science in our courtroom is critical to the American business community, both when businesses are plaintiffs and defendants. The U.S. Chamber supports this legislation because it makes a neutral change in the law. It helps ensure that critical engineering, medical, and other complex substantive fact-finding can be made in the courts based on scientific principles that, at the very least, are more likely to be right than wrong. As we've heard, that these changes nationally have been widely accepted. They haven't proven to be controversial. They were made at the federal level in 2023 and have been widely followed and endorsed throughout the federal courts. Similar legislation, as we've heard, have been quickly adopted in a number of states. And again, a lot of times they're being passed without any opposition. And these reforms are working. They are needed to give effect to the decisions that Missouri, along with the federal courts and many states, have already made. And that is to make judges gatekeepers of expert testimony, ensure that any expert testimony presented to juries result only from sound scientific principles. The expert must meet certain qualifications for offering their testimony, and their testimony must meet certain the statute's objective criteria for reliability. And then the judge must determine that the testimony meets this criteria by a preponderance of the evidence. In other words, the judge has to make sure the scientific testimony is at least more likely to be right than wrong. And if opposing experts offer competing but sound scientific principles, juries can competently weigh the credibility of each expert and their testimony. But the juries cannot do this job if the courts are not being proper gatekeepers. The problem is that some courts, we saw this federally, are still applying outdated admissibility concepts from obsolete or mistaken case law, namely that there is a presumption for admissibility. A couple of my colleagues at Shook did a study of how federal rule was being applied and found errors in every circuit. And then did a follow-up study after the 2023 amendments were enacted and found a lot more consistency across the courts. By underscoring what courts are already supposed to do, these amendments help weed out expert testimony that's too unreliable for juries to rely on to make critical design defect causation and other complex, consequential scientific determinations. And the impact here also has very real-life consequences. Judicial rulings are not just about liability, they are about public safety. When a jury finds that a product is designed defectively, for example, the manufacturer is on notice to go back and redesign the product consistent with the jury's findings. But if redesigning a safe and effective product based on testimony that has not been shown, particularly by a preponderance of the evidence, to be reliable, would lead to products that are less safe and could cause more harm. And that would undermine product and workplace safety. And this is a particular problem for regulated industries where state and federal agencies have processes for reviewing and approving scientific and engineering practices. And these processes should not be undone based on scientific theories that, again, are not more likely to be right than wrong. In conclusion, the U.S. Chamber urges adoption of this bill to protect the sanctity of Missouri courts. Thank you so much.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses testify in support?
Good morning.
Welcome.
It's good to be here. Thank you for having me, and thank you for hearing this wonderful bill from Senator Berger. I appreciate him also bringing it forward. I am Holly Thompson-Rader, working on behalf of Midwest Sterilization Corporation in Jackson, Missouri. So this is a hometown company that has over 200 employees and is very beloved by us in SEMO, but also they sterilize about 40% of hospital surgery trays across the U.S. So very important company. They are a woman-owned business, and this bill is important to them, as you can imagine, with them using ethylene oxide for their sterilization. They are extremely technical and a regulated business. So having different rules from federal to state in something as important as expert witnesses, it matters to them. So I'm here to testify in support, and we've passed out our testimony, and I'm happy to answer any questions.
Yes, thank you for that testimony, and it has been distributed to the committee. Any questions for this witness? Seeing none, thank you for being here.
Thank you so much.
Further witnesses in support? Please proceed when ready.
Rich Albachon on behalf of the Missouri Civil Justice Reform Coalition and the American Property Casualty Insurance Association in support of the bill.
Thank you for that testimony. Any questions for this witness from the committee? Seeing none. Thank you again. Further witnesses in support?
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries Missouri, want to go on record in support of the bill. Happy to answer any questions.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Mr. Chair, members of the committee, Jared Hankinson, representing Missouri Chamber of Commerce Industry, would like to go on record in support of the bill. Thank you very much.
Thank you for that testimony. Questions? Seeing none. Thank you. Oh, we have a question. Please proceed.
How do I know that you're an expert witness?
That's a great question. One that I'll defer to an expert on. Thank you.
All right. Seeing none. Further witnesses in support?
Mr. Chairman, Jeff Smith testifying on behalf of the ACLU of Missouri in support of the legislation. If you've got the U.S. Chamber of Commerce, the Missouri Chamber, and the ACLU, it must be a pretty good bill.
What a broad-based coalition. Further, any questions for this witness? Seeing none. Further witnesses in support?
Mr. Chairman, members of the committee, Tom Crawford here on behalf of Missouri Trucking Association to go on record in support. I submitted online. So.
Thank you for that testimony. Any questions for this witness? Seeing none. Further witnesses in support?
Good morning. Katie Gamble here on behalf of the Missouri Railroad Association. Want to go on record in support of the legislation.
Questions for this witness? Seeing none. Further witnesses in support?
Good morning. Hampton Williams with the Missouri Insurance Coalition testifying in support of this bill.
Any questions for this witness? Seeing none. Further witnesses in support?
Good morning, Mr. Chair, members of the committee. Philip Arnzen with the National Association of Mutual Insurance Companies. We'd like to go on the record in support. And Senator, I am not an expert witness, but I'm sure we can find somebody that would be.
Thank you for your regular witness testimony. Any questions? Seeing none. Further witnesses in support? Seeing none. Witnesses here in opposition? Please come forward. Make sure you fill out a witness card and proceed when ready.
Feel like I need a long line of people to follow me. My name is Michael Sudicum. I'm here on behalf of the Missouri Association of Trial Attorneys. I'm also a practicing attorney in this state for 25 years, have handled cases throughout the state. My office is in St. Louis, Wentzville, and Paris, Missouri, but we handle cases throughout the state. So I feel like I have a good understanding of how judges operate their courtrooms in the various circuits. I've been in big circuits. I've been in smaller circuits containing multiple counties, and had the opportunity to be in front of our great judges in all of these circuits. So the changes to this bill, our statute, are more than just changes in words to mere Rule 702. It seems, and it's very simple to say, like, well, we're just changing these words. But when we change words in a statute, they have meaning. They are going to have a substantive impact on every courthouse in the state of Missouri. And that's judges in rural counties, judges in urban counties, judges with mixed dockets. So unlike a federal court where they get very specific, and I heard mention of, well, the not having law clerks is just not a thing, that doesn't matter. It does matter. And when you practice law in a court and you handle cases, things like that do matter. And if you've ever seen a motion to strike and ever been sent over a box of this motion to strike an expert, you'll realize it's not more than just a simple gatekeeping procedure that a judge is just going to take a look at and make a quick determination. And judges do have a gatekeeping function, and they always have in the state of Missouri. There has always been, under our expert witness statute, requirements. And even after the changes in 2017, I found it curious that the Hewitt case was brought up, and that was a case where, as the witness testified, the defense healthcare provider offered a witness that was ultimately struck by the Court of Appeals. And the Court of Appeals, using the 2017 changes, said admissibility of expert testimony under 490-065.2 requires simply that it be relevant and reliable and pro-offered by a qualified expert. An expert may be qualified on a particular topic by her knowledge, skill, experience, training, or education. Reliability is determined by considering whether the testimony is based on sufficient facts or data, reliable principles and methods, and reliable application thereof. So, judges already have guideposts. Attorneys already have guideposts how to find an expert, retain an expert, and if that expert offers an opinion that supports the case, they know what needs to be done. It's been argued that these are just clarifying these requirements and these checklists, but it's going to make it less clear. If you actually look at the first change, and it's that the proponent demonstrates to the court that it is more likely than not. So already at the outset, you have a judge requiring to make a threshold determination of facts and the methods considered by the expert. So it's not just whether or not this expert is a qualified individual who reliably relied upon information and used an accepted methodology. The judge is now making a threshold factual determination by adding this language to the case. And that, without question, is a harder call and an inappropriate call, given that factual determination should be the province of a jury, and will require more work for the judges, slow our litigation dockets, slow trials, and I heard earlier that our courts are already backed up. And so it is a real change. It is that's not just a simple change when you practice law in these cases and handle these cases. That's a real change. The second change that in the wording and I know it mirrors the federal rule, but reflects a reliable application of the principles and methods. And so I actually looked up the word reflects because I found it to be an interesting word to use in a statute when putting a burden on a judge to reflect upon what an expert's saying in a case. To me, the word reflects offers no clarification and only more confusion as to what a judge has to do. The word reflects has multiple meanings, and we can all look them up, but it just, by adding that word, you're adding more gatekeeping with less certainty, and in nowhere does it say what reflects a reliable application means. I mean, that sentence could mean anything to a number of different judges. And so you consider, we hear a lot about, on a national basis, what experts do, and maybe these are federal cases when you have big litigation in federal court, which is it's a different kind of case. And if you practice both, you know that they're different kinds of cases. But if you have a simple Missouri case where you have a treating physician who treats someone who, like me, represents people in car accidents, someone breaks their leg in a car accident, the treating physician says, yeah, I fixed it, I did surgery, that's what I do. And they had the car accident, broke it. Their opinion, they're experts, they're qualified experts. They're qualified experts based on their education, experience, and training. When you get into all this methodology things and all that, and that's the reason why certain district courts exclude treating physicians from Daubert reports. And I know we don't like to use the word Daubert anymore, but the colloquial term. That's why they're excluded, because what they do doesn't fit into the confines of this federal rule and this proposed changes in 918. In fact, in a district court case, a U.S. district court case, after their changes in 2023, the district court says it's the responsibility of the court to determine the expert's opinions are reliable rather than deferring that determination to the jury, even when the opinions rise from the expert's experience. And so that is not consistent with Missouri law. That's not consistent with our right to a jury trial. That is totally disregarding someone like a treating physician's expertise as a witness. And this statute has the potential to make whether or not a treating physician is an expert who would qualify under this statute more difficult. And so I don't think that that's something we need in this state. I don't think it's something that would benefit our courts. I do think it's an additional burden on our judges. And I kind of wanted to finish with one last thing that I heard, where there was discussion of how this applies equally. And the rule, all court rules do apply equally to both parties. I agree with that. But what it does impact, and what I think I would ask the committee to consider, is that increased costs. Those increased costs may be more easily borne by a corporate defendant. Those increased costs may be more easily borne by a coalition, and maybe it's easier for a multinational corporation to bear those costs than a local collective of hospitals. But all parties are going to bear increased costs when you increase the burden of expert testimony. And that's true in cases that I handle, such as personal injury plaintiffs. That's true for criminal defendants. That's true for local governments in prosecuting cases. That's true for any kind of litigation. And so that is a real reality of these changes to this statute. For those reasons, I would ask you to, I'm here in opposition to this bill, and ask you to vote no on it.
Thank you for that testimony. Questions for this witness from the committee? Yes, please proceed, Senator.
Good morning.
Good morning. Thank you for being here. So I think all of us we hear regularly from constituents about affordability. It seems like, you name it, things are getting more expensive. So I appreciate your testimony, but could you, when you talk about making things more expensive for our constituents and costs, can you just walk me through what that would look like? So say I, had a broken ankle from a car accident. So I'm your client. How would that, me, just an individual, I'm not a corporation, how would that, what would that look like?
Sure. So I appreciate it. What it does is it requires an expert, whether a retained expert or a treating physician, to spend more time making sure that they comply with the kind of requirements of these proposed changes. And experts, like plumbers, like electricians, like everyone, charge for their time.
Mm-hmm.
And so if it requires them to do more work than they would normally do, normally a treating physician you'd pay their deposition fee, and they'd read from their records and tell you what happened and what they did and what's the result. When you have these increased burdens, they're going to have to spend more time looking through their methodology, and they're going to look at me very strangely and say, well, I'm a doctor, that's my methodology.
Yeah.
But so that's going to increase the time. And in an example of a personal injury case, that's going to increase the cost that's ultimately borne by you as the injured party. When the case resolves, there's going to be an increased cost to you, and that reduces your recovery.
Okay.
And so in that instance, that's how that, in my world, that's how that would
Okay.
apply. And while I don't do family law, there's experts often in family law, and those costs are often immediately paid by the parties themselves. And so they're
So
going to
earlier in the process then?
earlier in the process.
Okay.
So they're going to have increased costs when they need an expert to testify that their spouse or partner is committing bad acts. That's going to take more time and more money to do that.
Okay. Thank you. I appreciate the real life examples.
Thank you.
Further questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses in opposition?
Good morning, Mr. Chairman. Good morning, Mr. Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. This SB 19, in my opinion, is for special interest. There is a heavy lobbyist in this room, a lot of high-paid guns by private corporations, by the insurance industry, by liability lawyers. This is highly against the plaintiff and Missourians who truly need access to the courts. The courts are being increasingly complex, increasingly unaffordable, and increasing against your common Missourian plaintiff who has a claim against a corporation or against the insurance industry. Missouri residents deserve fair trials. It sounds to me like money is the marching tune to this bill, which is unfortunate for our state politics, our state government, our state judicial system, and the courts as a whole. These changes are highly against the plaintiff and highly a slap in the face to the common Missourian. These changes are costly and almost out-of-pocket reach for a common Missourian. This highly is in favor of big corporations, defendant trial attorneys, and the Missouri insurance industry. Witness testimony is subjectable to different judges. Just because the federal courts believe one way is not the way that we do business in judicial law in Missouri, and we're titled the Show Me State. We don't take marching orders from the judicial federal courts or from Washington, D.C. We set our own tone, our own laws, and our own state statutes right here at home. The courts are becoming increasingly complex and not accessible to me by the common Missourian. The cost for filing a simple civil lawsuit before a circuit judge just increased from $110 to $167. I didn't do the percentage, but that looks to me like a huge increase. Maybe it's because we are $2 million in deficit spending in our state budget. Maybe we're trying to recoup costs from additional taxes and additional fees on the shoulders of plaintiffs, of Missourians who truly deserve to be heard in the courts, whether they're right or wrong. They deserve a fair and ample trial before a judge or a jury. For those reasons, I'm highly opposed to Senate Bill 918. Thank you, Mr. Chairman.
Thank you for that testimony. Any questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses testify in opposition? Seeing none, are there any witnesses here to testify for informational purposes only? Seeing none, that will conclude the public hearing on Senate Bill 918. I will now turn the gavel over to the Vice Chairman for the remaining two bills.
I'm assuming that means, because our chairman has Senate Bills 973 and 881. Okay. I've got my marching orders from the chairman. We're going to proceed with Senate Bill 881, presented by Senator Trent. When you make your way to the microphone, please proceed when you're ready.
Thank you, Mr. Chairman, members of the committee. For the record, Curtis Trent, representing Senate District 20. Senate Bill 881. This is the bill which prohibits third-party foreign financing of lawsuits. Increasingly, you have bad faith foreign actors that are willing to use our court system as a sword against Missouri businesses, engaging in hostile and frivolous litigation that damages their reputation, wastes both their and taxpayer resources. This measure will stop that practice and protect Missourians. It is, in fact, a very simple bill in what it aims to accomplish. I know we say that a lot, but this actually is very straightforward. I'd be happy to answer any questions that the committee has, and I believe we have some witnesses here to testify on this as well. Well, any questions that the committee has.
I've heard a few bills this morning already, but that's the first time I've heard the term simple bill, so congratulations.
That's right. You know, somebody has to
on
break
getting that out of the
in
way this year.
First time of the year, yeah.
Are there any questions for the senator? Senator McCreary.
All right, so I'm looking at 881. How are you trying to target, like, the bad actors?
So we're targeting foreign entities that do not have an interest in the lawsuit itself. So they are not direct parties of the lawsuit. They are funding a lawsuit that is being brought by other parties. In many cases, without even any interest in repayment. They are simply financing a lawsuit which is being waged against a Missouri or an American business. As you can imagine, if there's not a financial incentive in that, then there's some other incentive that drives them to that behavior. Some of these actors are foreign companies that wish to hurt the reputation of American companies, or even foreign governments that filter money through to engage in these kinds of destructive practices. And so that's the conduct that we're aiming to try to curtail.
I think your words don't quite match up to the language I'm seeing in the bill necessarily. So, when you talk about bad faith foreign actors, I'm thinking of, the countries that we discuss when we're talking about foreign corporate ownership of ag land, that kind of thing. So this seems like it's pretty broad. Like you only want there to be.
Well, these are defined terms, and so I'm happy to go over with them, or we can read them right here.
Well, I know how to, I can read. I think your words, the way you're describing it doesn't quite match up with the language. That's all I'm saying.
Well, I'm happy to work with you to more closely tailor the language
Okay.
if you think that we have not narrowed in on the target.
So your intent is only U.S. funding of everything?
No. So I think it is appropriate for individuals who are foreign entities who are before courts as a party to the lawsuit to be engaged in that conduct. We're talking about third-party funders here.
Okay, so only third-party funders, your intent is only third-party funders would be,
Third-party funders
USA.
who are not American entities.
okay, thank you.
Further questions for the senator? I think I'm going to put it in layman's terms for me. Let's say BMW or a German car company. They're sitting over there watching some litigation happen between, say, Ford and GM, and they want to jump in to help the lawsuit there. Is that kind of what you're trying to?
So I think
because their
maybe
competitor, is the Ford Mustang or something like that.
Yeah, the type of example that I would give as a hypothetical would be you have a foreign competitor car company, and you have a lawsuit between an individual and an American car company, and that third-party foreign car manufacturer who's not a party to that litigation in any way comes in and funds the plaintiff to bring a lawsuit that otherwise probably the economics of the case would not indicate it should be brought. So it's a frivolous claim. Like there's really not a case there. But if someone is willing to bankroll that lawsuit, then it is able to proceed when otherwise it probably would not. With the intent being to inflict reputational harm on the company and
competitor.
then increase their share of market value.
Okay. Thank you for
As
that.
a hypothetical. There are other hypotheticals that could work as well, but to hold to your hypothetical.
Layman terms. Yep.
Yes.
Okay. Thank you for the clarification. All right. Any further questions? Seeing none, we will go witnesses in favor of the legislation. So witnesses in favor of Senate Bill 881, please remember to fill out a witness form.
Thank you, Mr. Chairman, members of the committee. My name is Phil Goldberg. I'm a partner with the law firm of Shook, Hardy & Bacon, which is based in Kansas City. I work out of our D.C. office, and I've been asked to testify today on behalf of the United States Chamber of Commerce. This is an important topic because third-party litigation financing is fundamentally changing civil litigation, and its abuses have been felt by plaintiffs and defendants alike. The Chamber's goal is to make sure the courts can produce fair and accurate results for the people of the state and for those doing business here. The Chamber fully supports this legislation because it fixes a key abuse in third-party litigation funding, which is the manipulation of courts by foreign entities. I want to start, if I can, with a little bit of foundation in that third-party litigation funding generally is fairly new. It's really a development over the past 15, 20 years, never part of the litigation landscape before, and has now become the driver, according to a lot of experts, behind mass tort patent and other types of litigations, commercial litigations, that change every aspect of the civil litigation system. Professor Maya Steinitz has talked about how it decides which cases are brought, how long they are pursued, when they are settled, and is only becoming a greater and greater factor in the court systems. And so, to be clear, the focus of the reforms that the Chamber supports, including this legislation, is where investors are manipulating the courts and interfering with the ability of the plaintiffs and defendants, who are the true parties in the case, to resolve their disputes and use the courts to achieve justice. At some level, even the words financing or funding are misnomers. It's really about investing. These are often hedge funds, institutional investors, and others who buy into a lawsuit for a financial return. Just like you would invest in stocks or mortgages, instead they are investing in lawsuits. Their structures of how they do this have changed, and they change seemingly every couple months to be very sophisticated, like any financial mechanism. The finances, the risks, the taxes are large drivers, also structuring them to try to avoid reforms. over the past 15, 20 years, this has become a huge industry. According to the U.S. Government Accountability Office, TPLF doubled from 2017 to 2021. The major funders, and this is self-reported, so it's, everyone assumes these are very low numbers, have $16 billion of assets in U.S. litigation. Expect that to double by 2028. And that mass torts, you regularly see $50 million, sometimes hundreds of millions of dollars behind it. And this whole thing has gone from like 0 to 60 over the past 15 years with no rules of the road in order to protect the integrity of the litigation process. This particular legislation is important because it fixes one of the major problems with this kind of investing, which is, again, foreign entities manipulating to take advantage of American courts to undermine justice and U.S. litigants. The GAO report in 2022 found that TPLF investors included foreign money from sovereign wealth funds, international competitors, and adversaries. Burford, which is one of the largest funders in the world, is a public company, so there's some knowledge in terms of their workings. Had an $872 million agreement with a sovereign wealth fund, though there was not identified who. And Mythic Capital, a Saudi investment firm, has a 10% stake in Burford, as it was reported. Fortress, which was reported that they have about $10 billion committed in U.S. litigation, that a sovereign wealth fund from the United Arab Emirates now owns 68% of Fortress. Most funders are private hedge funds, so there's no reporting on where they get their funding, so no doubt this is the tip of the iceberg. In 2023, Evan Turgeon, who was the chief of the Foreign Agents Registration Act at the Department of Justice, expressed concerns about the risks of TPLFs, that foreign entities would seek competitive advantage by taking U.S. competitor, tying them up in expensive and high-stakes litigation. They would try to use litigation in the U.S. to gain access to U.S. companies' proprietary and confidential information through discovery, and that they would be funding litigation on political issues in order to affect the U.S. political climate. And all three have been happening. In 2024, the FARA chief, Turgeon, issued a letter stating that domestic attorneys must register with FARA if they're taking foreign TPLF. And this was a response to a question from a lawyer that was hired by an Australian funder who owned Fortescue Energy, which had a competing line of energy business from the American entity it sued. The litigation was highly speculative and political, and so they were funding not just for the finances, but according to the countersuit, to shift U.S. policy and the business market away from the American company and to the Australian company's products. In 2023, Bloomberg News reported that a Chinese firm was financing IP cases in the U.S. Purplevine IP Operating Company was a Chinese-based IP services firm, financed at least 4 IP lawsuits in U.S. courts when its involvement was involuntarily disclosed thanks to a TPLF disclosure from a Delaware federal judge. The cases were against Samsung Electronics and were filed by an affiliate of a Florida-based private equity firm. The disclosure, subsequent reporting, and facts that were learned at trial suggest that Purplevine received and relied upon privileged, confidential, and highly sensitive information in bankrolling the patent claims. And so there was a concern about the misappropriation, discovery, and other confidential litigation materials. Former U.S. Attorney General Michael Mukasey, in a Wall Street Journal article, talked about VLSI technology, which had foreign funding, including from I'll probably misstate this, but Mubadala, an Abu Dhabi-owned sovereign wealth fund, they sued Intel over its semiconductor chips, and Mukasey reported that Mubadala is the largest owner of Global Foundries, a competing chip manufacturer. In March 2024, Bloomberg reported about A1, which is a subsidiary of Russian financial giant Alpha Group, funded lawsuits in the United States in violation of international sanctions. After Bloomberg published this investigation, Deputy Treasury Secretary Wale Adeyemo addressed this issue in Senate testimony, saying A1 actively participated in New York and London litigations ranging in involvement in day-to-day decisions to direct legal strategy from Russia. These episodes, again, are just the tip of the iceberg. It's just what has come out, as we have seen from reporting and from certain disclosures. The U.S. Chamber of Commerce has issued multiple reports, which we can provide to the committee, highlighting how these episodes and how foreign TPLF are problematic. They undermine fairness of the U.S. legal system by allowing foreign entities to influence litigation outcomes without transparency or accountability. They have significant economic and national security implications. They pose risks of misappropriation of intellectual property and other confidential information to foreign, rival, or other governments, and they can try to control domestic policy by funding divisive political litigation. And the economic dynamics for this foreign funding is only getting more attractive. Senator Tillis introduced legislation in the U.S. Senate because he found that foreign funders were pulling their money and their proceeds out after a settlement without using arcane aspects of the tax codes, which some say wrongly, to assert that their proceeds are not subject to taxes here in the U.S. And so litigation funding is highly lucrative. Burford has said they make over 90% return on their money, and it's not subject to global economic trends. So this legislation, therefore, is a critical step to stopping a key TPLF abuse. The Chamber supports its enactment and hopefully as soon as possible. Thank you.
What TPLF, what's that stand for?
Third-party litigation financing or third-party litigation funding, depending on who you're talking to. Again, I think it's more third-party litigation investing. I think financing and funding are misnomers.
That was my assumption, just wanted to make sure. All right, any questions for this witness? Seeing none, thank you for testimony. Another witness in support of Senate Bill 881, please come forward.
Dana Freese testifying on behalf of the Missouri Organization of Defense Lawyers. Third-party litigation funding operates largely in secret as opposed to disclosure of insurance information by organizations such as mine, available to satisfy a judgment or settlement for the defense. Third-party litigation funding is primarily a profit-driven business designed to generate returns for investors and can be at the expense of the plaintiffs it is supposed to help. Third-party litigation funding can allow funders to take control of cases and prevent the actual parties to the lawsuit from settling the case, as the funder can have veto power over settlement. And as noted previously, it also opens the door to foreign influence in Missouri courts. Senate Bill 881 strikes a reasonable and fair balance from a public policy standpoint by permitting responsible litigation financing, but limiting foreign funder influence and holding litigation funders accountable. Litigation should be managed and controlled by the parties and their counsel, not outside foreign investors. Thank you.
Thank you for your testimony. Any questions for this witness? Seeing none, next witness, please come forward.
Thank you, Mr. Chairman, members of the committee. Thank you for the sponsor for Senate Bill 881. Samuel Lee with Campaign Life Missouri to go on record and testify in favor of the bill. Very simply, this is a natural extension of bipartisan legislation that passed last year, specifically foreign funding of initiative petitions. That was something that Senator Ben Brown had as a bill. He worked closely with Senator Stephen Weber, and they worked out some technical things. They were in agreement in concept, worked things out, and passed overwhelmingly in the Senate and in the House, and became law, signed by the governor. And we think it's important that if we're going to prohibit foreign donors or foreign actors from trying to influence our elections, then we should also prevent them trying to influence our court cases. Happy to answer any questions.
Thank you for your testimony. Any questions? Seeing none. Next witness in favor, Senate Bill 881.
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries of Missouri, want to go on record in support of this legislation.
Thank you for testimony. Make sure you're getting your witness forms filled out and turned in. As another reminder, any questions? Seeing none, next witness in support of 881.
Rich Albichon, registered lobbyist on behalf of the Missouri Civil Justice Reform Coalition and the American Property Casualty Insurance Association in support of the bill.
Thank you for testimony. Seeing no questions, next witness in favor.
Matt Barton, CEO of the Missouri Association of Insurance Agents, going on record in support of the bill, and thank you for sponsoring it.
Any questions? Seeing none, next witness in favor.
Thank you, Mr. Chair. Members of the committee, Jared Hankinson, representing the Missouri Chamber of Commerce and Industry, would like to thank the Senator for bringing the bill forward and go on record in support.
Thank you for testimony. Any questions? Seeing none. Any further witnesses in favor?
Thank you, Mr. Vice Chair. Hampton Williams with the Missouri Insurance Coalition testifying in support of the bill.
Any questions? Seeing none.
Good morning, Mr. Chair, members of the committee. Philip Arnzen with the National Association of Mutual Insurance Companies, known as NAMIC. We'd like to go on the record in support.
Thank you for testimony. Any questions? Seeing none. Any further witnesses in favor of Senate Bill 881? All right, we'll flip to the opposition side. First witness in opposition, Senate Bill 881, please come forward.
Thank you, Mr. Vice Chairman, members of the committee. Kind of feels like deja vu a little bit. Again, my name is Michael Sudicum on behalf of Missouri Association of Trial Attorneys. The concept of, I heard a lot of testimony on the litigation funding, not specifically on the bill itself, and the concept of litigation funding where any limitations on the ability of a individual or a smaller company to fight a larger entity is something we're against. The concept that a bad foreign actor influencing our courts and our cases and hurting our businesses is obviously something that all of us are concerned with, and I can't imagine anyone saying that's not a concern. But when you look at the bill specifically that's in front of us, and it's not addressing litigation funding, whether it's good, bad, or indifferent, the bill defines foreign principal as any government, person, or entity described as the Foreign Agents Registration Act. It goes on to say that a foreign principal or agent of a foreign principal shall not directly or indirectly invest in, finance, fund, or loan money to litigation funder in this state. And the concern with the bill itself, not the concept of litigation funding, because that's not what the bill addresses, is we live in a world where we have major international financial institutions, such as U.S. Bank, a publicly traded company, who provides, or their subsidiaries, lines of credits to law firms, both plaintiff, defendant. We have other banks that do the same. The idea that those banks and the shareholders of those financial institutions don't have foreign investors, which would be precluded under a broad reading of this bill, really limits the ability of, and if you look at the definitions of a law firm to, because it uses words like indirectly, that could potentially fall within the provisions of this bill, which would make a law firm getting a line of credit that they use to finance their law firm, as many businesses do, that would prohibit them from a bank from providing that line of credit to businesses in this state. For that fundamental reason, we're opposed to this bill. There was a lot of talk about litigation financing, and I'd be happy on a separate occasion to get into the merits of litigation financing, the protections that the courts already provide in terms of protective orders from data, and I understand why they are against litigation financing or funding, however you want to call it. But that addressing this specific bill, that's a major concern, because it's not just whether or not Purple Vine is funding a case against Samsung, which is not pending in the state of Missouri. It's a bigger attack on the concept itself. And what I know about high finance, I know from the TV show Billions. And so there is, and I was provided, and I'd be happy to share with the committee, an entity called Underwood Ranches in California, since we're outside of the Missouri anyways, who is a farm, and or ranch. They like to be ranches in California, I guess. And they had a contract with a company, and I apologize if I mistakenly, Hui Fong Foods, that terminated their contract with them, and they grew peppers for their sriracha sauce. And this, the ranch had limited access to funds, and during the course of the litigation, they actually won their trial and were awarded damages, and of course, the defendant appealed. And this ranch, this small business, comparably to the defendant, was running out of capital to fund their appeal. And Buford, who I don't know nothing about, funded, but I heard them mention, so this letter struck me, funded their appeal, and ultimately the case resolves. But so there is an importance to this concept. I agree that we should keep bad actors out of everything, but I just don't think that this bill as it's written does that, and is sufficiently tailored to do that. Thank you.
Thank you for your testimony. Any questions from the other member up here? Senator McCreary.
So my layperson's reading of this could also, because of the word indirectly, does that mean that you'd have to find a bank that only has investments that are U.S. based?
As I read it, I think that's right. I mean, that's if you read it, I think that's correct. And wish every bank in. I'm sorry if I took your question.
My question was for you.
Yeah, okay, thank
Yeah.
you. Yeah, that'd be great, right? If every bank in the state of Missouri
Well, but
was
probably
owned by,
not, because
But they're
then
not.
that means they're not getting the best return on investment
Correct,
for
because they have a
their
fiduciary
customers.
duty to their
Right.
shareholders.
Right.
So yes, I think as it is, that would be required to be a strictly U.S. owned entity.
Okay, thank you.
And then, oh, I'm sorry. And the other, there is, never mind. I'll just let it be.
You good? Okay. I have no questions. All right. Further witnesses in opposition, Senate Bill 881.
Thank you.
Good morning again, Mr. Chairman, or Mr. Vice Chairman, members of the committee. My name is Arnie C., AC Dinoff, State Public Advocate. Keeping foreign companies, keeping foreign countries from backing litigation of residents. We need to use some common sense here. This Senate Bill 881 is ridiculous. It's not right. If you read in the definitions of this bill creates a Class E felony. It creates liability, cost, and mandatory sanctions by the circuit judge on a foreign company from entering and financing a lawsuit. What about candidate finance laws and ethics? We have foreign contributions that go through state campaigns through the side door, through a PAC, a political action committee, almost on a daily or weekly basis right here in this building. So if we're really going to get foreign companies out, why don't we start with politics and Missouri ethics laws and regulations? This is a special interest law, once again, just like the previous bill. It's amazing that we have 12 lobbyists to each elected official in this building. The amount of money that it's financed by American corporations in business is astonishing in this building. A lot of the elected officials forget why you're here. You were elected by the 225 to the 250,000 Missouri residents who sent you here. You need to put people first over lobbyists and corporations and big business. 80% of most Missouri products are foreign produced, are imported into the United States and into the state of Missouri. By doing this, you are limiting availability of Missouri residents to bring a lawsuit in side of Missouri courts. Let a judicial judge decide clearly the merits of the case and if there's a justifiable case. They can always dismiss the case with prejudice or without prejudice. The term is standing. You have to have a standing to bring a lawsuit as a plaintiff in Missouri courts, in any circuit court across our state. Standing is very important. In this law created, Senate Bill 881, it talks about Unlawful Merchandising Practices Act. And if so, the judge could find a foreign company for entering into a case, penalties, costs, and sanctions. How does this go to foreign relations with other countries throughout the world? Do you want a Missouri resident who travels to a European country or to a foreign country, whether it's China or Japan or another country? We have a lot of Missourians that travel. If they're hurt, if they're liable, if they're injured, or if they buy a product or become sick in another country, do you want another foreign country to pass rules and regulations that Missouri residents and United States residents can't have access to foreign country courts to make somebody responsible and accountable? Let's use some common sense here. What's driving this bill is lobbyists that are sitting behind me who are paid hundreds upon hundreds of thousands of dollars by special interest groups to make more profits and get more money for their pockets. I believe this bill is highly unconstitutional and on the border of a dictatorship. We are having rules that is coming from Washington, D.C. that is bordering on a dictatorship, and we don't want that here in Missouri. We want our courts to be fair, ample, and open to 6.2 Missourians. This is taking over control of the courts. The courts are independent according to our Missouri State Constitution. They need to remain independent. I believe in judges, whether they're elected or appointed by the governor, with a commission-type base. My preference is elected circuit and associate circuit judges throughout the state. But my confidence is that they know when a bogus lawsuit is being brought, whoever the plaintiff may be. Financing is a tricky situation, but the same concept goes to each one of your campaigns. Who is financing your campaigns? What PACs donated to your campaigns? Did these people behind me donate to your campaigns on this committee? You know what? Maybe I should do some homework and some in-depth finding and look and see who donated to your campaigns and who is pushing this bill 881. It's clear. It's on the table, and it's a shame and a slap in the face to Missourians, just like the last bill. I will come here to Jefferson City. I'll take time out of my day. I'll make the private expense to come here to fight for Missourians because these type of bills infuriate me, make me upset, get my blood pressure up, get my stress level up, and I'm not going to tolerate this type of conduct on behalf of Missourians. I'm tired of lobbyists running this building. It's time that Missourians are put first and our citizens come first. Thank you, Mr. Vice Chairman.
Thank you for testimony. Any questions? Seeing none. Any further witnesses in opposition? Senate Bill 881. Anyone for informational purposes only? All right, seeing none. That concludes testimony on Senate Bill 881. And it looks like the last one for the day. Last bill for the day will be Senate Bill 973, again proposed by Senator Trent.
Thank you, Mr. Chairman, members of the committee. Again, for the record, Curtis Trent representing Senate District 20. So Senate Bill 973, this is the bill that would require, before entering into a contract that transfers an interest in residential real property, a wholesaler, which is a defined term under the Act, acting as a grantee or wholesaler's representative, must provide a written disclosure to the owner of the property. And we specify what the requirements for that kind of disclosure is. If the wholesaler fails to make such a disclosure, then before entering into the contract for a piece of property, the owner of that property can cancel the contract, and disbursement of funds that were paid by the wholesaler has to be distributed within 30 days of the cancellation. Any violation of this act is made an unlawful practice under the Missouri Merchandising Practices Act, and we give the Attorney General enforcement capabilities. The goal here is to prevent transactions that really look a lot like fraud, where you are having a wholesaler that's coming in and basically seizing the bulk of the value of a piece of property as it's being transferred, rather than what you would normally see in a normal market transaction between a buyer and a seller. And we're not outright banning these practices, as some probably advocate for, because it is a freedom of contract issue. But we want to make sure that people who are engaging in these kind of practices have ample notice of the negative consequences that could accrue to them, including loss of potential value that they could get out of their property. So this is a consumer protection bill, and with that, I'd be happy to answer any questions from the committee.
Does the committee have any questions for the bill sponsor? Senator McCreary, please proceed.
Thank you. Could you give an example of like what this looks like, how it would impact our constituents? I think I'm familiar with what you're talking about because there's been a lot of media coverage over the interim.
Yeah, I mean, a hypothetical I think would be apt to be, someone comes in, offers an amount of money for a house, let's say, and that amount is below market value. And so they enter into a contract with the seller. They give them that, the below market value price for the house. And then they go out and immediately sell it, or even in some cases they use the proceeds of who they sell the house to finance the amount of money that they give to the seller, whatever the buyer gives, and they just pocket the difference between what they're giving the seller and what the buyer has given them. And that is really money that if it had been a free market, open market transaction, the seller should have rightly and normally received that money. And so you're purchasing essentially a service of questionable value for a very large sum of money, and it's marketed and done often in a very predatory way. And so these disclosures would alert a seller that this kind of practice is on the table, this is what could be happening to them, and that puts them on notice that they need to either investigate that further or find another avenue to sell their property.
Yeah, I think that makes sense. I think the newspaper in my region has covered some of these things, so I can think of some real life regional examples. One of the things I worry about, though, is like when you go to sign all those papers on the day, like you go to the I know everybody's supposed to read everything before they sign it, but I feel like you're signing your name 1,000 times, and even when I look at the following disclosure that you have in your language, it's written in, it's not the easiest to understand. So do you have any flexibility in trying to be more straightforward and not have it be such legalese?
I mean, we could attempt to if you think there's a way that we could simplify it that would accomplish the same purpose, I'm certainly happy to look at that. We do require them to sign that they have read that. I mean, at some level, if they're signing that they have read when they in fact have not read.
No, I get that.
I understand that can happen.
It's been a long time since I've had this kind of transaction, but it's really overwhelming to read everything, and you feel this pressure to like just sign, and get out of there because there's somebody else. And I think when we interact with constituents, one of their frustrations with a lot of the official documents is they're written in a way that only somebody maybe with a legal background can understand. One of the things I would love to strive for is that things are written in a more, maybe 8th grade level or something like that, so that we are truly trying our best to communicate with people.
Certainly. Happy to have that discussion and see if there's any way that we can accomplish what we're trying to accomplish and accommodate that kind of request, because we certainly want this to be useful to the people who are going to see it.
Right, right. And then within this type of transaction, is there that, you can get out of it within a certain number of days? 'Cause,
Yeah,
I remember-
so the landmark is that they failed to make this disclosure, then they can cancel a contract before the close of escrow without penalty, and the money
Okay.
be returned within 30 days of the cancellation.
Okay, very good, thank you.
Seeing no further questions from the committee, we'll go witnesses in support of the legislation. Make sure you fill out a witness form and leave behind.
Thank you, Mr. Chair and member of the committee. For the record, my name is Jason Zamkis. I'm a registered lobbyist appearing before you on behalf of the Missouri Association of Realtors. This is a problem not just in Missouri, but nationally. And there's a number of states that have tried to tackle this issue, and they've done so in a variety of different ways, from outright outlawing the practice to requiring additional state licensure and for that matter, local licensure. This legislation is modeled off of states like Ohio and Oklahoma that have tried to strike a balance. In many situations, especially where you have a more sophisticated buyer, wholesaling does provide a legitimate option when looking to sell a piece of property. And so this is narrowly tailored to preserve legitimate wholesaling activities as an option for Missouri homeowners, while at the same time putting in place safeguards that protect the consumer and enforcement mechanisms that will root out and stop bad actors within the industry. And for that reason, we'd like to go on record in support. And Senator McCreary, to your point, perhaps maybe we could have this is a condition precedent to entering into the contract. Maybe we could have a time frame in which it has to be delivered in advance of the actual closing, so they have more time to actually review. It's not a lengthy document. They could review it, sign it, and then engage in closing at a later date.
Thank you for your expert testimony. In my reflection, I would say you're an expert on that matter at this juncture.
Thank you.
Seeing no further questions from the committee, next witness in support of Senate Bill 973.
Thank you, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, State Public Advocate. First of all, wholesalers, and if you go to county collectors' sales at county courthouses, wholesalers, in my opinion, are swooping into several communities across Missouri, mainly Springfield, Joplin, St. Louis County, Kansas City, Jackson County, Columbia, some other areas, and they're buying multi-pieces of property in one deal, either from another corporation or another owner who might own some rental properties, or from the county collector tax sale that's held in August of each year for the failure to pay county real estate taxes. This bill is good transparency. It wards off fraud and bad actors. It gives a direct reliance to a Missouri purchaser of real estate of transparent and open documents notifying the buyer that this is part of a wholesaled transaction. I would like to ask the sponsor or a member of the committee to amend Senate Bill 973. As Senator McCreary stated, there needs to be common sense, direct written language. A lot of times, a lot of these instruments, when you go to the title company, Senator McCreary was correct, you might sign 40, 50, 60 documents, and it's a fast process. They want to try to get you in and get you out as fast as possible. You go through documents. You don't have a predetermination on most of the documents to read, to understand, to meet with a attorney. A lot of them are written by an attorney. They're not written for the common sense Missourian, and there's a lot of people that don't understand what they're signing. They're trusting the title company. They're trusting the real estate agent or the real estate broker. Sometimes they're led down astray and down the wrong path. And so this needs to be written in a common sense, direct notice to the buyer that these are part of a wholesale transaction. This is great consumer protection, and I like the enforcement by the Office of the State Attorney General. I would ask that this protection law, that it provide, I'm not sure, I read the bill, it was kind of unclear. It says you get your money back in 30 days, but I would ask for an amendment that it would provide for some type of day of a cancellation, whether it be 10 days, 14 days, or 30 days of a contract cancellation. It needs to be on the side of the Missouri consumer and not on the side of the wholesaler LLC corporation, who has limited liability under our state and under the Secretary of State's office. In my opinion, I like that the Attorney General has enforcement power of the Office of Attorney General. This is great common sense legislation, unlike the last two pieces of legislation that we talked about. And so I am full support of Senate Bill 973 with the amendments and recommendation that I proposed. Thank you, Mr. Vice Chairman.
Thank you for testimony and questions. Seeing none. Thank you, sir.
Thank you.
Any other witnesses in favor? Seeing none. Witnesses in opposition? Seeing none. Informational purposes only. Again, seeing none. Senator, any closing comments? No comments. And with that testimony, this concludes the hearing on Senate Bill 973. And as Vice Chair, seeing no further business for the committee, I adjourn.